we are in the chapter of proof. So you understood the meaning of what is relevancy of fact. This is actually we are in admissibility. Relevancy chapter देख लिया हमने. The admissibility and proof के ऊपर आ गए हम. These are section 56 onwards. Please note that in the Evidence Act, the relevancy deals with section 5 to 55, and the admissibility deals with 56 onwards. Admissibility. Admissibility is 56 onwards. You should know that here. That is what we are going to cover. 56 to 100, you may say that is the meaning of it, is devoted to the admissibility as well as a proof of the document. Yes. Now let us come to section 58. Now admitted fact to khatam ho gaye. Oh, yes.
59, sir. We have to do 59.
59. That is yes, oral evidence. 59. Oral evidence, chapter number 4, isn't it? Oral evidence. Yes, oral evidence. Yes. So section 59, so evidence is a various type here. Oral evidence, documentary evidence, primary, secondary evidence, वो सब deal करेंगे अभी. Yes. Yeah, section 59. All facts except the contents of document. Contents of document, underline the word, or electronic record. So electronic record भी normally are written document. वो तुम्हारे email होता है, WhatsApp होता है, isn't it? CCTV camera होता है, it's in a document. So those are the documents. The something which is a document, content of document, you cannot give oral evidence unless you bring it before the court of law. So you are not permitted to give all facts except the content of document. The document mean the primary evidence, section 62, and mode of giving primary evidence 64, and documents containing under section 63 and 65 secondary evidence, and electronic record, which is now recently added under section 65A and B. So ये सब चीजें you cannot give oral evidence. You are required to produce the document before the court. Otherwise, section 59 permits that parties are permitted to give oral evidence. What is oral evidence? Zabani. Somebody who has seen it. What is exactly oral evidence? Somebody who will see what exactly what the act says that here. When you open section 59, all fact except the contents of document underline karo and electronic record may be proved by oral evidence. So this is one of the requirement before the court of law. Parties are at liberty to prove, give evidence of oral evidence. Oral evidence is normally given in illustration. Check करेंगे आप that anything. See, facts include anything, state of thing, relation of thing, any mental condition of which any person is conscious. Section mean the definition के अंदर है that there are certain objects in certain orders that a man heard. Illustration B, that a man heard or saw something is a fact which can only be given by oral evidence. Illustration illustration B, that a man said certain word is a fact. तो उसने बोला, you have seen it yourself, it can only be given by oral evidence. That a man holds certain opinion as to certain intention, as in good faith, fraudulently causing. ये सब चीजें, that a man has certain reputation is a fact. So these are things which oral evidence can be given of certain thing, it is not that only a person who can speak can give evidence. Somebody who may be mute, somebody who may be deaf. The other witnesses, 118 rakholi aap, who are the other witnesses who can give oral evidence? You will come to know. 118 खोल लीजिए. Who may testify? All persons shall be competent to testify, mean give evidence, unless the court consider they are prevented from understanding the question therefrom, or from giving rational answers to those questions by tender years. Example, old age, disease, body, mind, anything. Explanation, a lunatic is not incompetent. So somebody, a man of unsound mind, is also a competent witness if a doctor certifies that his lunacy is not of a permanent nature and he may be a schizophrenic patient. घंटे में दिन में 4 घंटे ठीक रहता है, 6 घंटे खराब, then again cycle changes. So in those hours his evidence can be given unless prevented from lunacy, from understanding. Then 119 कहता है, witness unable to commercially verbally, a witness who is unable to speak may give evidence. Somebody is mute, gonga आदमी, somebody is unable to give, he can give evidence in an intelligible manner by writing, by signs. बताएंगे signals, there is also oral evidence, or by writing something may be written, or signs in the open court evidence. So these are all oral evidence which a sign gives. So it is not that only a person who is fit can give evidence. The oral evidence can be given by various persons. Okay, that is section 59 deals with oral evidence, mean a person who has seen who testifies, a person who heard it who testifies. It doesn't say that derivative evidence. That means I heard from C that A stab B is not recognized here, except in other cases of section 6, 7. So that is called derivative evidence or hearsay evidence. So section 59 doesn't speak about hearsay evidence. It speaks about the direct oral evidence. Number one. Number two, 60. Oral evidence must be direct. So the evidence which is sought to be given orally by a person who has seen it, by a person who has heard it, by a person who on account of being mute he is giving through signs, it must be direct. In all cases, direct, that is to say, it refers to a fact which could be seen. हमने illustration में check करे अभी section 2 के अंदर, somebody who has seen it with his own eyes, it must be the evidence of a witness who says he saw it. Yes, I have seen A committing the crime. I have seen A robbing from this place. I have seen B running away when the police came. So these are the direct witnesses. Yeah. It refers to a fact which could be heard. Somebody who personally heard it. It must be the evidence of person who says he heard it. So these are the examples of a direct witness, direct evidence, which you will also find from the expression of fact in section 3 interpretation clause के अंदर. Okay, those illustration will give you what exactly meaning of a oral evidence. Then again it says that here, if it refers to an opinion, an expert opinion, we learned section 45, 46, 47, 48, 49, 50. कल ही पढ़े हमने. If it refers to an opinion, somebody is giving an opinion, or the grounds on which opinion is held. Somebody is holding an opinion that we learned under the provisions of opinion as to usages, opinion as to customs, opinion as to right of way, opinion as to signature, opinion as to relationship. These are the circumstances. Even under section 32 में check करे आपने, we learned that somebody is giving opinion given by a person When a person is dead or who cannot come, he is giving opinion of several person expressing feeling or opinion with regard to custom under section 13. That is section 32(7). So यहाँ पे it refers to opinion and the grounds on which opinion is held. It must be the evidence of a person who holds the opinion on the ground. So when a custom is in dispute or a usage is in particular is brought before the court of law, an evidence which is sought to be established under section 13 of the Evidence Act to prove a particular custom, that must be of a person who is having knowledge about, who holds the opinion on this ground, particularly a very senior man in the village. This is a custom in the village that after the birth of a child, this particular rasmo rivaj take place. Or at the time of adoption taking place in our village, the rituals take place in this manner. The ritual takes place of a child, girl who is of 10 years or maybe 12 years, boy of 15, 13, 30 years, maybe of any age, there is no bar. So the person who holds the opinion where the custom is prevailing, he must directly come and depose, that his evidence will be direct. Provided that the opinion of experts expressed in any treatise commonly offered for sale on the ground on which such opinion are held may be proved by the production of the treatise. If the author is dead, it cannot be found or has been incapable of giving evidence, cannot be called as a witness without the amount of. So the requirement of section 32 of the Evidence Act are incorporated. So the gentleman who gives opinion should be available before the court of law. In case he is not available, dead or not traceable, and his treatise can be produced before the court, his work can be produced before the court, his report can be produced before the court to prove that this is what he held it. Provided also that if oral evidence refer to the existence of a condition or of any material thing other than the document, court may, if think fit, require the production of the material thing for its inspection. Because the court is deciding the judgment. You know that here a fact is supposed to be proved, disproved, or not proved after considering the entire matters before it. So it may not be evidence, it's a matter before the court. Mean the material which is sought to be proved, the condition, it says that that material must be brought for the inspection of the court. If sometime the matter may be on in a Himalaya mountain, maybe on a tree inscription, you cannot approve the tree and bring it to the court. But you may appoint a court commissioner. You may say that under the provisions of Order 18, Rule 18 CPC, the court itself has a power to come and inspect it. Aap padhe. Court's power to inspect the property. Both CPC also contain, CRPC contain. Commissioners can be brought to before the court of law. That evidence can also be laid. So judges can personally visit the site and see. That's a matter before the court. Whatever the judges have seen it and perceived with a sense, it's a matter. It becomes a matter evidence before the court, where the court can record a finding in that regard. So section 60 is very comprehensive. It covers several situations where the evidence of it, you may also call it, they contain the best evidence rules. Section 60 along with section 62 and 91, 92 of the Evidence Act, they are known as best evidence rule. It's a superior evidence. It's a high quality evidence and the court will accordingly certify if the witness is truthful in all particulars. He will be called a sterling witness. When first class witness, a believable evidence, he has given a truthful narration of fact, or the court will brand him, it's a witness speaks, his evidence is not worthy of consideration. Or a good witness or a chance witness, witnesses are various types. The Supreme Court and High Court has given various characteristics. They have coined the evidence in their own manner. Of course, the Evidence Act doesn't do that. But whatever way the judges have coined it, that becomes law itself. So, Section 59 clearly tells you 50 and 60, oral evidence is recognized, oral evidence can be given. 59 bars oral evidence of a written document and electronic record. Electronic record के बारे में, a message which is brought on email or a photography of a videography message, you cannot orally depose कि मैंने देखा. You bring it before the court of law. That cannot be proved. A lease deed is before the court of law. You cannot give contents of the evidence on the contents without the document brought before the court of law. So bring it here. But there are circumstances under 91, 92 which permit, I will take you through how. But normally at the threshold there's a bar. The bar which can be lifted. I'm telling you that. Yeah? The legislation has kept a window open for every word. If you cannot lead the best evidence, it doesn't mean the end of your case. You have a right to lead oral evidence. अगर oral evidence नहीं मिला, documentary evidence. Documentary evidence नहीं मिला आपको, no problem. Secondary evidence, primary evidence. Then you can lead circumstantial evidence. So there are various types of evidence the Evidence Act speaks about. So mind you that 59 and 60 speaks of oral evidence. Oral evidence, not only the parties, the witnesses, a dumb witness can give it. Somebody is handicapped, somebody is unable to speak, he can give it. Signs, he can give it. 118, 19 of the Evidence Act, you must remember in that regard. Okay, that is called the evidence of oral evidence, which is permissible, which is recorded by the court of law of the witnesses who had done. So before I shift to the other topic, that is section 61, 62, 63, 64. Yeah, then say proof of contents of, yeah. Anybody wants any question on the oral evidence? Please ask me question. I am now taking the documentary evidence. Okay, documentary evidence पे आ जाइए. Proof of contents of document. So what you learn from section 5 to 55, relevancy of the document. Now from 56 onward, you are learning how they are admissible, admissibility and proof. So Evidence Act speaks of, number one, relevancy of a document. तो हमने section 5 में कहा कि the parties are not permitted to lead any evidence save and except in fact in issue. Number one, and relevant fact. So section 5 tells you lead evidence only with relating to fact in issue, the issues which are framed under Order 14 and the charges which have been framed under the CRPC 211 onwards. Beyond that, you are not permitted to lead evidence. That is called the fact in the facts in issue. Then Evidence Act कहता है कि you lead also evidence relevancy of fact. Relevant fact, they are enumerated from section 5 से लेकर 55. Please note that. They are relevant. Relevancy of fact is different from admissibility of fact. Relevancy of evidence is different from admissibility of evidence. So section 56 onwards, they deal with admissibility. So the relevant fact which you are collected, now you show how it can be admitted. How you can gather proof of it? That is the role of this section. From section अभी देखिए 61 onwards लेके 100 तक ये proof जाएगा अभी. How various documents are exhibited, what kind of evidence, if A is not available, B not available, C not available. It's a very interesting sequence. You will be enjoying learning this because 56 and 59 and 56 tells you about oral evidence. Okay, 61, 62 पे आ जाइए अभी. The contents of document may be proved either by primary or secondary evidence. So section 59 बार लगा दिया. You cannot prove the contents of a document by oral evidence. Please note that. आपके पास एक लीज डीड है, मॉर्गेज डीड है, और ये व्हाट्सएप मैसेज है, you are not permitted to just give evidence that of oral nature. Let the document be brought on record. That is what section 61 says. The contents of document may be proved either by primary or secondary evidence. Now, what is the meaning of primary? The original document. Secondary evidence means the primary evidence is dealt under section 62. Please note that here. Again, primary. Secondary evidence is dealt under 63 and 65. Now, let us first see primary evidence. Now, section 61 says that here primary evidence or second. Two types of evidence you are permitted to prove the content. Number one, primary evidence means the document itself produced for the inspection of the court. So, the document itself means the original document, the main document. वो document आपको court में लाना पड़ेगा. At the time, the parties are presenting their examination chief and evidence, or at the time direction is given by the court, issues have been framed, or the parties are hereby directed to produce before the court their list of documents disclosing the original document which they seek to rely upon, and complete the inspection part by the next date of hearing or before the commencement of the actual trial. This is the order normally a trial court passes. Be ready here. So keep the original document. Tell your client, your document produce करे आपने plain में not sufficient. All original document लाइए, एक file बनाइए इसकी, separate file. One original file and a Xerox copy of the file. Two Xerox copy preferably. One original copy. Original will be for the court. One copy will be for the opponent. One copy for yourself. And I will say, make another copy for the court. You can tell the court, my lord, the original document which I am producing, maybe some of them are ration card, passport, you may be required to travel. You can tell the court, by keeping them, the trial may go on for 1 year, 2 years, for longer time. My family is traveling abroad next week. So your lordship may kindly mark this document by comparing it from the original copy, and the original may be returned back to me by retaining the Xerox copy of the document after marking. And I undertake to produce the document as and when required. That you should make as a clever lawyer. Otherwise, आपको difficulty आ जाएगी. Because that provision वो इस आपको evidence act पे नहीं मिलेगा. When you open the provisions of order 13 मिलेगा. खोलिए आप. Order 13 खोलिए. Order 13. That is what you have to make. So you made the files. Order 13 खोल लीजिए. Rule 1, 2, 3 and 4 समझा दूंगा मैं. See, order 13 says original document to be produced at or before the settlement of the issues. So no sooner pleadings are ready, the court is keeping the matter I am keeping the matter for settling the issues. Both the lawyers are directed to produce the list of the draft issues. Draft issue file होते ही court commence a trial. That is the expression trial is not defined in CPC or CRPC. You have to see the legal dictionary of the dictionary. Mean it is where the examination of the witnesses commence. See, the parties or the pleader shall produce on or before the settlement of the issues. On or before mean they issue all the documentary evidence in original. So a mandate is contained that you should produce before the court of law all your documents which a plaintiff mentions in Order 7, Rule 14, and which the defendant describes them under Order 8, Rule 1A in original at the time of the trial, where the copies thereof have been filed along with the plain or written statement. So those documents only you be permitted to file, which are already annexed. Number one, you are also permitted to subsequently additionally produce more document, but uske liye you have to take the leave of the court. See that the court shall receive the document so produced, court le legi, provided that they are accompanied by an accurate list thereof, prepared in a such form as the High Court directs. So the list is prepared, list of document on which the party, right? Then nothing in the section shall apply to document produced for cross-examination of witness other party. This is like mentioned in explanation to Order 7, Rule 14, and also to explanation to Order 8, Rule 1A. Cross-examination document need not hand it over to the witness merely to refresh memory. So these two documents you need not disclose at this stage, but you have to inform the court, I have certain documents which I like to use in cross-examination. उसके अलावा Order 14 and Order 8 permit you additional document to be produced in evidence, but with the leave of the court. That the leave of the court, देख लीजिए आप उसमें देखिए Order 1, Order 7, Rule 14 खोल लीजिए. The expression leave has been used, Order 7, Rule 14, sorry. Order 7, Rule 14. Yeah. Subclause 3 पढ़िए आप. A document which ought to be produced in court by the plaintiff when the plaintiff is presented or entered in the list to be added annexed to the plain, but is not produced entered accordingly, shall not without the leave of the court, underline this word, be received in evidence on his behalf at the hearing of the suit. So you have to take special permission of the court in writing or orally. Then similarly, same treatment is given to the defendant under Order 8, Rule 1A. वो भी खोल लीजिए आप. Order 8, Rule 1A. Please check कर लीजिए. Order 8, Rule 1A. Duty of the defendant to produce document on which, subclause 3 check करें. A document which ought to be produced in court by the defendant under this rule but not produced shall not without the leave of the court. Underline the one. You have to take permission of the court. A leave लेने के बाद you are permitted to produce, and section Order 13 mandates that here you must produce the document in original. Now, when I told you the endorsement court लाएंगे तो the court will make endorsement in Rule 4 के अंदर. तो उसमें then when the document are produced, the court will pass an order, both the parties, plaintiff to give his say on the document, mean to file his objections with regard to admissibility, non-admissibility. What document is admitting, what document not admitting. Similarly, for defendant के लिए भी direction देगा court को. So you are produce the document, plaintiff to give his say. That is same in jawab. So the court will hear that objections are heard under section 136. 136 में बताया आपको मैं. You know that here. Under 136 of the Evidence Act, just to decide the admissibility, whether the document produced should be admitted or not, or should be rejected. Then वो order होने के बाद, then accordingly Rule 4 के अंदर endorsement is made by the court with regard to admitted document. The subject of the provisions of the next so following document, court will make the number and give it. I won't read it entirely, we have done it here. यहाँ पे numbering करेंगे. Then numbering होने के बाद you can make a request to the court, return the document the same are required, I undertake to produce it later on. वो provision आपको मिलेगा order 13 rule 9. Please see rule 9. Any person, whether party to the suit or not. Sometime plaintiff and defendant produce, sometime people from postal department, people from election department, people from electricity department, they'll produce document to show whether they are necessary. Then any person, whether party to the suit or not, desirous of receiving back any document produced by him in the suit and placed on record, shall, unless a document is impounded under Rule 8, be entitled to receive the document back. So a document is impounded when sufficient court's stamp duty is not paid. Under the provisions of the Bombay Stamp Act, Indian Stamp Act, there's a provision called Section 3435, and if the stamp is not paid under the Registration Act, Section 49. So the court will not receive them in evidence. The document will be sent to the anybody knows? The registrar of stamps for paying penalty. 200 times penalty uski. Okay. The adjudication proceeding होंगे under section 31 of the Bombay Court Fees Act और Indian Stamp Act के अंदर adjudication proceeding. तो कितनी penalty, जब तक वो मैटर नहीं आएगा ये document admit. Till then ये application करेंगे आप written document. Then number 2, where the suit is one of the appeal is not allowed. Number 1, where the suit is. So यहाँ पे ये provision में the court में considering your prayer that I am required to travel abroad, my passport is there, I am required to draw ration for my family, ration card may be written. These documents, your lordship may kindly compare this in, the documents have been admitted already. So Xerox copy of the file of the true copy may be retained, original may be given, and I undertake to produce. ठीक है, undertaking का देखिए बारे में कहाँ है आपको, clause B में आएगा. Undertaking to produce the original if required to do so. On the return of document admitted so and so. So court में undertaking देना पड़ेगा. So as a smart young lawyer, when you are in the court of law, always keep one extra copy ready, Xerox copy का. ये document admit होने के बाद request करो, make an order, a general order may be kindly pass, return of the original document with undertaking to produce the document. Yes, this is a very important clue for you in their practice. Yes. यहाँ पे 62 में आ गए हम लोग. Okay, this is how the primary evidence is produced under the provisions of Order 13, Rule 1 of the CPC. Admission take place. Under Rule 4, rejection take place. Under Rule 8, impounding take place. Refund take place under Rule 9. CPC को बोलना मत आवा. Even CRPC के लिए you can invoke CPC because by virtue of Section 5, that is the saving clause, there is no bar. If there is a provision in the CRPC doesn't contain a substantive rule with regard to admissibility, non-admissibility, rejection, projection. But the rules of Evidence Act and CPC can be equally applied because the provisions are supposed to be pari materia or analogous provision, a procedural law provision, saving clause as के अंदर. Saving clause permits you to utilize, to invoke the provisions of the other act. Please note that. Okay. Section 62 में आ जाइए. Primary evidence mean document itself आ गया, original document. Explanation 1 देख लीजिए. Where a document is executed in several parts, each part is primary evidence. Sometimes documents are written in duplicate and triplicate because one copy is given to purchaser, one is given to seller. दोनों original, दो stamp paper मंगाते हैं. दो 100 rupees के stamp. So they are different parts. Both are original. So you need not prove almost everything. एक prove किया तो काफी है. Number 2, next page पे आ जाइए. Where a document is executed in counterparts, each counterpart being executed by one of the same parties, only each counterpart is primary evidence as against the party is executing. So I gave you an example. So the purchaser and seller entering into a contract for sale, agreement of sale under section 54 of the Specific Relief Act of the Transfer of Property Act. So purchaser बोलेगा मुझे भी वही एक original चाहिए, and vendor of course will have one copy. So two stamp papers, two papers will be prepared, and both will be signing it, both will be typed. So only one document can be proved before the court of law. You need not bring both. You may just make a statement. There were two counterparts. Explanation 2. Where a number of documents are all made by one uniform process, as in the case of printing, lithography, photography, each is a primary evidence of the content. So अगर वही document को cyclostyle कर दिया गया है and original signature है, isn't it? Political parties manifesto रहता है उसके अंदर, thousands of pages जाते हैं, electronic signature. So each of them are primary document, primary evidence, but where they are copies of the common original, they are not primary evidence. But if you have taken Xerox copy of the same after sign करने के बाद, but they are not original. But printing करने के बाद each page has been signed by both the parties, then that is the primary evidence. Sign होने के बाद, if you take Xerox copies, they cease to be the original. They become secondary evidence. Okay, remember that. So, section 61, 62 speaks about documentary evidence. Before we come to 63, 65, we must also know 64. Proof of documentary evidence by primary evidence. Documentary evidence must be proved by primary evidence except in the cases hereinafter mentioned. So, the document must be proved. It is parties are enjoined with a duty under the Evidence Act to first and foremost, section 64 should be read along with the provisions of Order 13 Rule 1, which tells you bring the original document. Order 13 पढ़े हमने अभी. The parties and the pleaders shall produce on or before the settlement issue all the documentary evidence in original, underline the word. Order 13 Rule 1. जब तक original document नहीं लाएंगे आप, your evidence, your गाड़ी start नहीं होएगी. Merely because you don't have original, you don't lose a case. You may be having copies, which are Xerox copies. These Xerox copies, by way of a secondary evidence, can only be proved provided you have laid a foundation that the original is lost. Number one, मेरे पास नहीं है, गुम गया. What efforts you made them? Number two, they are in the possession of the defendant or third parties. What did he do? I have given notice under 66. ये फाउंडेशन है. ये फाउंडेशन आप डालेंगे और कोर्ट को कन्विंस करें. When you convince that I do not have primary evidence in my hand, which you are bound and liable to produce under 64, read with Order 13 Rule 1 CPC, I am helpless. I do not have the document. But I have taken Xerox copies of the same and given to my CA, given to my advocate, given to the municipal department. I will produce it. Or I have tendered them in the previous evidence. I have been able to collect it. So, number two, you learned it here, how to lead evidence of a primary evidence. उससे पहले सीखे आपने how to lead evidence of oral evidence. Okay. Next, आ जाइए. Two evidence you seek in oral evidence, primary evidence. Now come to secondary evidence. What is a secondary evidence? The illustrations are given, secondary evidence ke example, in section 63 and 65. We'll go to this. Secondary evidence come into play when you do not have the primary evidence in record. It must have been lost, must have been destroyed, or it is in the custody of others. Now see, what are the secondary evidence? Secondary evidence mean and include, it is inclusive, not exclusive, copies made from the original. तो ओरिजिनल से कॉपी लिए थे आपने. At the time of the making of the passport, I took my original Aadhaar card. I took my original ration card. I took my original bank statements. Isn't it? And even at the passport is a original document. You wanted to give it to somebody, police department is asking for it. Isn't it? So you made some copies from the original directly. आपका election का record भी है. So, for example, you were in possession of a premises for 15, 20 years. You wanted to go to some yatra, some pilgrimage. So you gave chavis to your good friend. And after returning 15, 20 days के बाद, महीने 2 महीने के बाद, you found that your house is ransacked, your documents are gone. All your original documents are disappeared. Now you are instituting a police complaint. Police बोलेगी document लाओ, नहीं मेरे पास. You are filing a suit under section 6 of the Specific Relief Act on the ground that you have been dispossessed without following the due procedure established by law. So you have to establish your possession, not your title, under section 6. बोलेंगे at the moment all my documents have been ransacked. Yes, I have been paying income tax. My CA has got it. I had some criminal case, 145 proceeding, and some document I had given to my lawyer practicing in criminal court. He has got it. So those are the documents which you may have made it from the original. So you take up the plea that here, these are the copies from the original made by me, made by my brother, my wife, my servant. Whichever person has made it, he has to come and give evidence. By mechanical process, बाजू में हमारे Xerox center है. I went to the Xerox center and took copies, which in themselves ensure accuracy of the copy compared with it. So the original document which I had in my possession, I took 100 copies to give it to various people. This was taken from the Xerox shop next door. And you may even examine the Xerox. Yes, this admi comes to me regularly at my shop for the last 10, 15 years. All copies, he comes, his children come. And he had come to me also on a given day, and the documents which I am seeing are all, yes, these are the papers, which is paper A4 size, a legal size, which I use, I buy. This is Modi Xerox company. This is from my Xerox center only. So your evidence with regard to secondary is substantiated or being corroborated, which law permits corroboration under section 156 of the Evidence Act. Corroboration. Or your augmented, your evidence is being supplanted, augmented. It's an auxiliary statement. It is coming in aid. So it is always good to advantage to examine the person who took the photograph. You just cannot say, I went to his shop and took it. You yourself give your statement before the court of law. I took the original to the shopkeeper next door to me and he made the copies. And also examine preferably the shopkeeper. Yes, this man, He has been, I know him for the last so many years. He is my neighbor. I have a shop, and almost every day he and his children come, and the document which is shown to me are made from my own Xerox, my company. So your evidence is corroborated. So copies को corroborate हो गए, you will be permitted to lead this. So mean your admissibility part के लिए help करेगा है. So you brought it to the court, relevancy you are satisfied. You told the court, this document is relevant to show my possession. Under section 6 of the Specific Relief Act, what you need to show, not your title, to show your possession. But what are the documents that can show your possession? That you have been staying, rent receipts, landlord statement, or society receipts, your ration card, your PAN card, that normally show your resident. That they themselves may not be titled document, but they document, these are the document lending credence to your statement that what you are deposing before the court is correct and true. Okay, that is how you prove this document. By mechanical process ये document लिए गए हैं आपने, and first evidence ये देने से पहले must tell the court the original has been lost. It is lost, it destroyed, and my friend whom I had given has stolen it. And you, when the documents are stolen and given, you give him a legal notice. That notice under section 66 mein dijiye. Rules as to notice. I put it to you that when I went to pilgrimage to so and so temple for so many days with my family, I trusted you as my friend and handed over you the keys. But you played foul. You took the law in your own hand, broke open, became dishonest, fabricated document, took possession of my flat, and made a bogus sale deed stating that I sold the property to you, which is a false contention. I hereby call upon you to produce the documents which you have stolen from my house and lodge a FIR. Please note that you just cannot give a legal notice. Tell the police officer theft has been committed under section 379, 380 of the IPC. From your house, this man has broken open your house. And you can also start your breach of peace proceeding under 145, 146 of the CRPC. You know that, no? The magistrate has power to attach your house. I was in possession, and this man has grabbed the property and he's come into possession. So magistrate is confused. He doesn't know at the moment who is in possession. Magistrate kya karega? He will attach the property under 146. He will appoint a court receiver directing the parties, go to the civil court, get your title decided. I cannot decide anything. I am not a competent person. That is the mandate of section 146 CRPC. So all of you know that here. पढ़ चुके हैं आपने CRPC के अंदर. When that order comes into play, merely going to the magistrate or executive magistrate is of no use to you. You will not be able to prove your title, both under section 6 of the CPC of the Specific Relief Act, as well as under section 6(4), a substantive suit of the Specific Relief Act, read with section 9 of the Code of Civil Procedure, where the court takes jurisdiction cognizance. So all the documents, you give a legal notice and file a FIR and preserve it. Tell the court here in the civil court. The reason I am producing this secondary document, I am seeking permission or leading because the original documents have been robbed by the defendant. I have lodged a FIR against him and also given him notice under 66. Police are not able to trace it. And even I invoke the provisions of 145, 146, the learned magistrate has attached the property. Seal the property with the direction that the competent civil court may pass appropriate orders. I am therefore praying that this honorable court be pleased to pass a mandatory order of injunction reinstating me in the premises, and this honorable court be pleased to appoint a court receiver, High Court Bombay, under Order 40 Rule 1 CPC, read with the supplemental powers under the CRPC Section 94, and the receiver be directed to give me possession, dispensing security and royalty, as I am the legitimate owner. So you cannot wait till the suit is disposed of, decided. It will take 6 months, may take 1 year, 2 years, sometimes 10 years. So immediately move for interim orders. So ये ट्रायल स्टेज के अंदर, that is a trial stage के अंदर, this is what you are required to do. The certified copies, how they are approved. Number 3 पे आ जाइए. Copies made from the compared to with the original. So even a copy which is, there may be 2 copies, 1 copy I told you here. Copies of, you are comparing with the original document. Yes, the court will see that here the original document was initially produced before this court and a copy was taken. It is on record, and certain documents were produced before the criminal code under 147. I am invoking your honor to take it on record pursuant to section 33 of the Evidence Act. These are similar documents. So they are the copies. So you can say they are the compared. You have to depose before the court. I am giving a deposition that the evidence, the document which is I am producing by way of secondary evidence is in fact a copy which was taken from the original by me before the institution of the suit. I gathered the document from my CA, from my school authorities, from the municipal authorities whom it was given. Next, number 4, counterparts of a document as against parties who did not execute them. So counterparts mean, say for example, landlord and tenant relationship. The landlord will issue a receipt and he will keep a counterpart. है ना? एक छोटी सी फाइल रखेंगे वो. That may not be signed, sometime it is signed. So it's a counterpart. Serial number रहेगा. Rent paid by tenant Mr. So and so on the ground floor, 100 rupees, landlord taking. Rent receipt दे दी उनको और एक counterpart अपने पास रखे, counterfoil. So that counterfoil becomes a primary evidence, secondary evidence. A merchant, a businessman will issue you a receipt, original document देगा, नीचे carbon copy रखेंगे, he will make the copy. A carbon copy is nothing but a secondary evidence. It's a copy made from the original. My नीचे ऊपर original, it is in my own handwriting, and I put the carbon copy and written down. So ये सब पुराने जमाने की बातें हैं, before the advent of your computer now, all this. Then number 5, oral account of the content of document given by some person who himself has seen it. Now oral account, now for example, it's very interesting. Oral account under the Mohammedan law, you must have heard of a document called Hiba Nama. सुने हैं ना आपने? Hiba Nama. Hiba Nama is a gift. Under the Transfer of Property Act, under section 124, 125, a gift must be registered. An unregistered document under section 17 of the Registration Act, not admissible. The document, the court will impound it under the provisions of Order 13, Rule 4, and also section 49 of the Registration Act. तो आपको भेजेंगे registrar के पास for adjudication, where you are liable to pay 200 time penalty. But for a Muslim gentleman who gives the property on orally, I have given this room, a flat or a bungalow to my elder son who looked after me. Elder son ले लिया. In the presence of 2 neighbors. And good neighbors. Yes. So the gift is orally made. कोई डॉक्यूमेंट नहीं उसका, बट यहाँ पे oral account of a content of a document. So these people, the witnesses, so the gentleman who made the gift died and gone, and the beneficiary, the son, is a donee enjoying it, and younger son has filed a suit, daughters have filed a suit for a declaration that we are entitled to equal rights or rights under the Islamic law. The son in possession will say, my father has given it by virtue of hibanama, which is a oral gift, in the presence of two witnesses who have made affidavit and declaration confirming that my father has given the oral gift. So oral account of the gift are being proved by virtue of the affidavit on 100 rupees stamp paper given by the witness is a secondary evidence. समझे आप? It's very interesting. It's very
Sir,
interesting. Yes, पूछो.
sir, isn't it like section 60 where you say that a person deposes before a court and says that he himself has seen such and such thing?
Section?
Section under the oral evidence,
That
section
is a direct
6.
evidence. That
Yes,
is a
sir. Yeah.
direct evidence. That is the oral evidence.
Yes, sir. But sir, here the person is also testifying to the extent of direct evidence.
But direct evidence is not sufficient sometimes.
Okay.
How you can that some court may say he's an interested witness, I am not believing him. Huh?
Okay.
He is
So
an
you have.
interested witness, but there is a evidence of the person he has given gift. The gift is invalid unless there are two witnesses. The two witnesses will have to file at least affidavit. They will file declaration. Okay, in our presence, this gift was given. So there is no gift deed under the Islamic oral gift allowed, but declaration is in writing. The declaration is called secondary evidence. I'm just giving you the illustration of a secondary evidence. Understood or not? Those of you who have understood the Islamic law, you will understand this. Huh? Because all of you know, first year में law पढ़े आपने. Islamic law के अंदर oral gift is allowed, oral will is allowed, wasiyatnama is also allowed. There is no requirement of a writing in that. Under the Transfer of Property Act, it is mandatory. So section 124 clearly देखता है उसके अंदर. This is subject to the Islamic law. Now open section 124. TP Act खोल लीजिए आप. Section 124, 125. Section 122 defines gift. 123, how gift is effected. Gift of the future property. One 129, say savings of donation Morris cause of Mohammedan law. Nothing in this chapter relates to gift of immovable property made in contemplation of death shall be deemed to be effective any rule of affect the any rule of Mohammedan law. Okay, 129 is the answer. Those of you in the classroom, of course, all of you have read about the Islamic law. That is permissible. So Evidence Act के अंदर you can give. It is not only in Mohammedan law. Some of the customs permit in tribal areas the oral transaction.
Sorry.
Assam, Nagaland, और जाके देखिए आप वहाँ पे.
From 9.
Pardon?
Sir, we have another lecture from 9 p.m.
बताइए when to stop. I am prepared to stop.
Sir, we will have to wrap it.
Try to keep my
it's-
lecture on a day when you don't have other lectures. Friday, Saturday, Sunday lecture है आपको अभी?
No, sir. No, sir. We don't have.
Keep yourself lock on those 3 days. I'll take maximum lecture. Abhi I'll stop
Sure,
it now
sir.
because I do not want to take it other lectures. 9 तो करीब हो गया अभी. So we'll stop it now. All of you enjoy Holi. Thursday, Friday को मैं मिलता हूँ. Friday को शाम में मिलेंगे. I am ready Friday, Saturday, Sunday. Subject to every student's suitability availability बताइए मेरे को. Okay.
Sure, sir. We
Okay.
will communicate.
Good night. And try and keep lectures on a day when we are not, because my lectures can go